Okay, so we're actually on chapter 11 now, and it is contracts and business law. If you have the old version of the textbook, it will still say chapter 9. I'll let you go ahead and read your goals and objectives on your own. And contracts are really important. They're an agreement between two or more people. The people have to have the ability to make a contract, and if the contract is not fulfilled, then we can sue over it. So it is possible to have an oral contract, but I always tell my clients if it's not in writing, it never happened. It's just going to be so hard to prove an oral contract usually, that it's just better to put everything in writing. I recently had a client that just bought a car from a friend of her kids, and she paid for the car in cash, and she got the title, and no agreement, nothing. A couple days later, the car completely went bad. You know, it's kind of almost a buyer beware situation. I mean, we were able to get the money to repair the car, but it was tough because it had nothing in writing. All right, so you have to have several things in terms of making a contract. You have to have offer, acceptance, consideration, legality, and capacity. So we're going to talk about each of these in turn. But an offer is showing some sort of willingness to want to make a contract. And I love to use examples from Craigslist for this because there's all sorts of bogus ads, if you will, on Craigslist. So one of my favorite types of ads that I see on Craigslist in terms of a legal perspective is the bait and switch ad. Okay, so if you just looked at this from the lovely menu page, you would see that this mirror was $1. But then when you actually click on the mirror or the listing, you see that it's actually $20. Okay, so what's the problem with this ad? So this really isn't an actual offer. It's more like an invitation to make an offer. So because they had $1 and then they put 20, it's an invitation to make an offer for $20. So it's not a real valid offer for $1, unfortunately. And people get upset when they see this kind of thing. It just kind of goes against our, I don't know, our fundamental sense of fairness. All right. Okay, so in order to have a valid offer, you got to have who. Okay, so obviously in our case of the mirror, it's whoever listed the mirror, and then you if you want to buy it. What? And we've got the picture of the mirror. A picture is usually better than a written description, but it does have a written description as well, which is good to have both. And then how the offer should be accepted. Now, if this offer can actually be accepted, it would have to be for the $20, not the $1 probably. And it could be accepted, or it would be an invitation to make an offer via text or phone call for the $20 price. All right, acceptance. The offer has to be accepted in order for there to be a valid contract. So if you went over to the Craigslist person's house with a mirror, handed them $20, they should hand you the mirror if they agree with taking that $20. All right. Oops. Okay, so this one you can read on your own. This one is important. Let's talk about it. Okay, there's two major types of contracts, if you will. There's the unilateral contract, and this is the concept that I promise to do this and you do that. Okay? And a bilateral is I promise to do this and you promise to do that. So bilateral, we got two promises and we're hoping to see the action on both of them. Every contract has to have some form of consideration. So consideration is something of value. And even in kind of not as formal contracts, they'll even put a nominal amount like $1 in because the court wants to see some sort of consideration. And usually that consideration should be somewhat related to the cost of actual goods. So if it's a house and you're trying to sell it for $1, court's probably not going to uphold that, especially if you look at the picture of the house in the PowerPoint. Looks very expensive, very nice, probably a $500,000 house if it's in Southern California. So selling it for $1 usually won't work. All right. We skipped legality of contracts, so going back to that. Sometimes people like to make contracts that aren't legal, and I found this really interesting website, and I'm not trying to offend anybody, but just trying to get the point across. Here's this website we're about to look at. It's called Hire a Killer. And it says, we'll take care of all sorts of problems for you, like dogs and senior citizens and in-laws and exes. This is not legal. It says you can anonymously pay through Western Union, but let's say somebody actually did. They wanted to kill, the picture shows George Bush for $24,999.95. And they send them money through Western Union. It's not a valid contract because it's for an illegal purpose to murder somebody. So the court's not going to enforce the killer killing somebody. There is a potential that somebody could just take that money and try to keep it. All right, another thing to have a valid contract, we have to have capacity. And that means that somebody has the legal authority, the mental ability to have a binding and legal agreement. So they need to understand the consequences of this contract, if you will. They need to not be visibly intoxicated when they make the contract. They need to not appear like they're suffering from dementia. So sometimes you will see people do wills and trusts, which is sort of kind of a contract. And they will actually videotape somebody discussing it and signing it to show that these people do not have dementia when they're making this will and trust, leaving all their money to their 19-year-old spouse instead of their kids, for instance. And then typically children cannot contract, and children typically is defined by under the age of 18 years old. Now, there are exceptions, obviously emancipated children. There's also exceptions if a child needs some sort of necessity item like food or shelter. All right, statute of frauds. I've renamed it the statute to prevent fraud. And it's basically the concept that certain kinds of contracts have to be in writing because otherwise there's too much opportunity for fraud. So some contracts have to be in writing. So let's look at those. We have, taking over somebody else's debt. So if you decide to assume somebody's credit card debt, or like a parent decides to take over the credit card debt for their child, that has to be in writing. Prenuptial agreements have to be in writing. So an older woman marries a younger man, and he wants her to agree to take care of them in the event that she dies before him. That contract entered into before they get married about their marriage has to be in writing. Contracts about real estate purchases have to be in writing. Anything that can't be completed within a year has to be in writing. Contracts for goods, anything that can be moved, an amount of $500 or more have to be in writing. And then finally, stocks and bonds should also be in some sort of rent form as well, the purchase of those. All right, so prenup, we already kind of discussed the definition of that one, so I'll let you read that on your own. And one of the most famous prenups of all time was Amy Irving's and Steven Spielberg's, because she had a written one on a napkin and she didn't have legal representation. Typically, somebody who enters into a prenup has to have the opportunity to have that reviewed by an attorney. So when she got divorced, she was in California. It was community property, and she got $100 million because the prenup that she and Steven Spielberg did on a napkin was not legally binding because it was written on a napkin and she didn't have the ability to talk to an attorney about it. So she got community property in the state of California and she got a ton of money. All right. Typically, everything about real estate purchases has to be in writing. Here's this website we went to earlier in class. It's the San Diego County Recorder's website. It's a public record website. It talks about mortgages, sales of land, and you can look up how much your neighbor paid for their house, sort of thing. Okay, so the Uniform Commercial Code talks about certain types of contracts. So let's look at the table of contracts. Sales, leases, checks, bank deposits, property sales. So it kind of gives you the sense that there's even more than what we talked about that might have to be in writing. All right. The ethics portion of this chapter talks about conflicts of interest. Attorneys and paralegals at all times need to avoid looking like there's a conflict of interest. And so we can't represent the husband and wife in divorce. We can't represent the co-defendants in a criminal case. But there's lots of other times when conflicts of interest potentially come up. For example, I had a client with a mental health issue, and his family wanted to have him committed. Now, can I represent both the family and him? No, because even though it might be considered in his best interest to get him committed, and he doesn't understand all the complications with that, he still needs and deserves his own attorney to try to explain it to him. All right, don't forget your questions. There's several from this chapter, hint, 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 for your final exam.